Welcome everyone to the Ontario Caregiver Organization's webinar series. These webinars bring together caregivers and subject matter experts to explore topics of interest to caregivers. We do this to support and engage chosen family members, friends, neighbors, anyone who's caring for someone else. My name is Katie Muirhead, she, her pronouns, and I'm going to be your moderator for today. We begin this gathering by acknowledging the Indigenous peoples of all the lands that we're on today. While we meet in a virtual platform with people joining us from across the province, across the globe, in fact, I would like to take a moment to acknowledge the importance of the land which we each call home. The land that I'm standing on today is the traditional territory of the Haudenosaunee and Anishinaabe peoples, many of whom continue to live and work here today. This territory is covered by the Upper Canada Treaties and is within the land protected by the Dish with One Spoon Wampum Agreement. Today, this gathering place is home to many First Nations, Métis, and Inuit peoples, and acknowledging this reminds us that our great standard of living is directly related to the resources and friendships of Indigenous peoples. As team members at the OCO, we are learning about the lands from which we work, exploring how we can be meaningful allies, and how we can support the recommendations from the Truth and Reconciliation Commission. We do this to reaffirm our commitment and responsibility to improving the relationships between nations and to improving our understanding of local Indigenous peoples and their cultures. We invite you to take a moment to reflect on the land where you are. And if you're not familiar with that, we will be sharing an interactive map that tells you which traditional territory your city or town sits on. And you can find that map at native-land.ca. Our webinar today is called Health Law, a primer for family caregivers in the mental health and addiction sector. So this is part one of a two-part series. And in this session, we will examine how the Healthcare Consent Act and Personal Health Information Protection Act affects individuals' rights, the roles and obligations of substitute decision makers, and give some practical strategies for navigating the healthcare system, as well as a lot more. I'd love to introduce you now to our speakers. We have two folks joining us today. Angie Hamilton is an executive director and co-founder of Families for Addiction Recovery, a retired lawyer and a parent of a child who struggles with addiction. She is a member of the Public Policy Committee of the Canadian Society of Addiction Medicine and a board member of the Ontario Family Caregivers Advisory Network. She was a member of the National Board of MAD Canada, or Mothers Against Drunk Driving, from 2014 to 2020, and the chair of their Public Policy Committee. I'd also like to introduce you to Mary Jane Dykeman. Mary Jane is a partner and co-founder at INQ Law in Toronto. She's acted as in-house legal counsel to 2 Toronto teaching hospitals. In her work, she regularly assists hospitals, long-term care and retirement homes, and community healthcare organizations in finding practical solutions to legal, clinical, risk and privacy matters, including mental health, consent, capacity, and substitute decision-making in difficult family issues. Since 2004, she has taught the mental health law course at the Osgoode Professional Development Health Law, and she has authored multiple sector reports with the Change Foundation on privacy issues and barriers faced by family caregivers navigating the healthcare system. So welcome, Angie and Mary Jane.
Thank you so much. Lovely to be here and to have this number of people. I appreciate that introduction. I think that the work that the Ontario Caregiver Association is doing is so important. I will declare first up that I am a caregiver. I have been through the system, in particular with my parents, and navigating the health system is not easy. I wish I could say from a legal perspective that the laws are clear, they coordinate, and there is no overlap and there are no gaps. I think we probably all realize that that is not the case. I know from a personal perspective in navigating, I have one sibling who also works in the health sector, and we found it exceptionally difficult. And yet this is what I do all day, every day, most days. So just to say, it's a long road for many. And I think particularly in the mental health and addiction sectors, there is a lot to do. And this kind of crowdsourcing, I think, is just so important. Get the resources where you can, hear from your peers. What are the strategies, whether they're formal or informal? The good news is I think some strides are really being made, but at the same time, we want to talk a little bit about some of the barriers that some of you may come up against. Now, I also appreciate some of you are sitting in other jurisdictions. I will make some comments about Ontario legislation. Some of it's quite specific, but a lot of the themes may well apply regardless of where you are. So I'll be up first and then pass it over to Angie, and we're going to monitor the chat and also have a chance for a good conversation and to hear from everyone as well. So that is me. We are previously DDO Health Law, now Inc. Law, just having rebranded very recently, and we continue to do all of this type of work. So none of this will be new to you. Obviously, being a caregiver is extremely challenging, and we want to make sure that we acknowledge that. It's very difficult sometimes to support someone who does not want the support. Legal system, the rules are sometimes difficult. What I do want to say to you is that in Ontario, we have the Healthcare Consent Act. We also have the Mental Health Act. The two sit side by side. They're not one and the same. And it is fairly critical to keep that in mind, because in some other provinces, that's not the case. In BC, for example, some of you may be familiar that, if someone is found involuntary, there is an ability to give them treatment. That's not the case in Ontario. You have to go to two different settings. You know that you are potentially the person's best historian if you can get the attention of someone who will listen. That said, as a caregiver, you may or may not be the substitute decision maker legally, the person who makes the treatment decisions. First of all, I always ask, is that person capable? Because if they're capable, no one actually should be turning to you. They should be turning to that person. But if the person is incapable, and I'm going to talk about what that means, it may not be you, it may be someone else. The privacy issues as well, we need to really account for. They start to bubble up. What is it that you can tell the healthcare team? And then what can they tell you? And sometimes there's a problem on that front. The team may be uncertain about what they are allowed to share with you. It may be that they are not allowed to without getting the consent of that individual. There's a particular clause in PHIPAA that I won't belabor. It's not going to be relevant to others from outside Ontario. But what we know is under the Mental Health Act, if you are in a situation where the Mental Health Act kicks in, and there's a Form 1 application for psychiatric assessment, then it works well because there is an ability to collect information. And you can call it collateral information. It's right on the Form 1. So you would be able to turn to the healthcare team and say, here's what I can tell you about my person and what's been going on, and here's what I'm worried about. So that could happen in a hospital emergency room. It could happen in a doctor's office. And if it's not the case, we have to figure out, well, what's the ability to actually have the conversation and start to share the information. And I think Angie's going to flag certain documents in the system where different organizations may say, we can't share information about the person with you, as hard as that is, but we can listen. And so unfortunately, I take you back to what we call PHIPAA, Personal Health Information Protection Act. There are some rules that limit that. So we're always looking for what authority do we have to share the information. And you can imagine that some of these healthcare providers are feeling a little pressured themselves. And we know you are, but we know they are because they're not sure sometimes whether they're allowed to share certain information. Do they have to go back to the person? Or if the person's incapable, are you the appropriate substitute decision maker? Do they have to go find the substitute decision maker to give consent for you to have that conversation? So that's tough. There may be information in the person's record that they've maybe, my dad has an appointment and talks about me. For example, there might be all kinds of family history in his health record, and yet only he has access to it or his substitute decision maker. I couldn't knock on the door and say, I think my dad was talking about me and I would like to have access to his records. I only get that access if I have legal authority, if I'm the substitute decision maker. And then on the other hand, there's an ability in PHIPAA, and there's similar rules in other statutes and other jurisdictions, and it's called lockbox informally. So could I, as the client, lock my own health record, and how far does that extend? The lockbox in PHIPAA, this informal term, means I could limit the ability of the healthcare team to share with other members of the healthcare team. So either within, let's say within a hospital, I could say, listen, I don't want you to share the fact that, I saw an addictions provider with the rest of the team. And you might be thinking, well, we would really like that person to share the information because it's relevant. And this is, I think, the frustration of families sometimes. They're saying, listen, there's relevant information we're trying to put in the hands. It's just difficult. So there's an ability to lock for purpose of sharing with other providers, but the lockbox doesn't really have anything to do with family caregivers at all. For one moment, back to the PHIPAA comment about timeliness and accuracy, I told you that you can, with a Form 1 application for psych assessment, the practitioner could then turn to you and collect information from you. There's also an opportunity in PHIPAA, and one that you could remind people of. If someone is saying to you, you know what, I can't share with you, and I can also not collect information from you, I'm going to have to go get permission. There's a clause, it's in section 36 of the Act, not that you necessarily want to cite legislation to them, where you would say to them, I think you're allowed to do it if you can't get timely and accurate information from my son. And I would suggest that at this point in time, given his situation, you can't collect it from him accurately or in a timely way. So please collect it from me. And then the last point I wanted to make there, because I know it will advance, is just that if there is a substitute decision maker for purpose of treatment, let's say you are the caregiver, your person becomes incapable, you're the substitute decision maker, you then make all of the related information decisions as well. We don't have to go back over to PHIPAA, the health privacy legislation. You simply have that broader authority. So I always ask, when we're trying to make some of these decisions, is the person capable? And sometimes the healthcare providers will say to me, the team says, well, yeah, Mrs. Smith is incapable. And I say, well, let's just back it up a little. Incapable for what? Because there are all these different legal tests, and I've laid out some of them there: treatment, admission to long-term care, ability to sign a power of attorney for personal care or for property, ability to manage that property or make that personal care decision. It just depends. So it could be about managing property. We're not going to go into all of those today. The time doesn't permit us to do that, but just to be aware, there's no finding of global incapacity. So there is this, piecemeal opportunity to say, I think, I'm presumed capable, but, maybe someone is going to assess me and determine that I'm incapable for the purpose of treatment, for example. So that's the one that I wanted to raise here. Treatment under the Healthcare Consent Act is, as it's set out here, for certain specific purposes: therapeutic, preventative, et cetera, diagnostic. The Healthcare Consent Act creates rules in actually two other situations. One is admission to long-term care. So you could be caring for someone, a senior, for example, who is potentially eligible for long-term care, and then they would figure out, okay, you're eligible under the Long-Term Care Homes Act, and who's going to make the decision? Is it going to be that prospective resident, him or herself, or is it going to come over to a substitute decision maker? And we still have to figure out, is that you? We'll talk about the hierarchy. There's one other type of capacity in the Healthcare Consent Act, which I didn't put in here. It's about personal assistance services, but it's typically if you go into long-term care and you need a two-person lift, a Hoyer lift, or whatever kind of thing, there are decisions to be made there. But I don't want to talk about personal assistance services today. I think mainly here, we're talking about treatment. Some of you may be dealing with a long-term care issue as well. So just giving it some thought, the capacity, as I said, is presumed. I'm presumed capable. We are all presumed capable for purpose of consenting to our own treatment. It does not matter if I am diagnosed with a mental illness. Well, it may have an impact on my cognitive ability, which is part of the legal test, which I'll talk about. But the starting point is we are all capable. And I don't want to say, unfortunately, the fact is that means we're capable to make a poor decision. And so I think this is also the frustration that some people have. If you have a family member, and you may also quite legitimately believe that they are not capable, and that the health care providers are not getting it right when they assess the situation. So we're going to look at the legal test. I mean, basically, in a nutshell, I'll give you the 30-second version. We worry about the ability for you to be able to share information that is really important to you, stuff that your person is not telling the healthcare team. And exactly. And it's always going to be a challenge. So what we look to is, if you come up against that roadblock, then what are we to do about it? And I had said in a prior slide, we don't have to go back. I said, we're always looking for the legal authority as the healthcare team. And I mean, not to say they're going to pause and think, oh, what does PHIPAA say about it? But we know, for example, if you bring the person into a merge, or by whatever means they get there, we know for a fact that on a Form 1, there's an ability of that healthcare practitioner to write in, to collect any collateral information. So that's great. Have your collateral information ready to go. It's so important, because you may have a split second to convey that. So that's your opportunity, but that's only in that particular situation. I mean, make notes about times and places and events and things and get it down to, it's almost like an elevator pitch, for lack of a better word. If you have a split second to impart good information that is not being shared by the person, then that is your opportunity. So great, they can collect it if it's collateral on the Mental Health Act side. But generally speaking, I'm actually not convinced that every healthcare practitioner knows that there are limits in PHIPAA as to what they are allowed to collect. So PHIPAA hasn't been around forever. We used to say, and I was in-house to the Psychiatric Patient Advocate Office, and we used to say, listen, physician, you can't share information, but you can collect, you can listen to the family. That changed with PHIPAA a little bit, but that's why I pointed you to a clause in Section 36 that says one exception to the prohibition on collecting is if the healthcare practitioner can't get it in a timely or accurate way. And that's why it's just extremely important. Practice saying out loud, literally, if you're getting a barrier, to say, I think the privacy legislation lets me share this with you if you can't get it in a timely or accurate way from anyone else. And I think this is the right circumstance. So again, we want to get to the point where, you have it right down to your elevator pitch. You're taking every opportunity to give the very best information to the people who will listen and get it into the flow of where that's going. So I've said capacity is presumed. What if the person's diagnosed with a mental illness? The diagnosis is not the issue. I could be in early onset dementia. I could be diagnosed with schizophrenia. It does not necessarily mean that I am incapable for purposes of treatment. It matters as to the status of my illness. And I know families often talk about, the point at which someone lacks insight and how they can put together a good game and have a conversation with the healthcare practitioner, who then says, oh, everything's fine, even though and in many ways, you're the person who is still managing this. We've had people who go into hospital, for example, and they get discharged, and the receiving family members have very little information about what has gone on or how they can help and everything else. So we've got to kind of break through that impasse. And again, capacity to consent to treatment in Ontario under the Healthcare Consent Act is assessed by the health practitioner who is proposing the treatment. It's not done by a formal capacity assessor that gets brought in. It's the practitioner, often a physician, proposes a treatment. and presumes that the person's capable, or pauses to think, you know what, I must do a capacity assessment. We'll talk about what the legal test is. So if we advance the slide, that would be amazing. Okay, so here's the legal test. Healthcare Consent Act, Section 4. I rarely put things in bold, caps, underline, and everything else. I did it all here because it's the main thing to take away from this is there's no age, there's no diagnosis that governs. We have to look to the legal test. And the legal test is a two-part test. And the person, if they fail one prong of this test, they are incapable. You don't have to fail both parts. And the most important thing is, it's not just, do I understand the information I'm being provided? Or, you know, do I know what the consequences are of saying yes or no? It's, am I cognitively able to understand? It's a cognitive test. Is this person able to understand the information that they're receiving? And over 20 odd years practicing in the area, what we've seen for the most part is many times your person is cognitively able to understand the information. They may be quite sophisticated. They may pass the first prong of the test. Where they often don't pass the test is in the second prong. They may be able to understand the information, the practitioner gives it to them, and then they cannot apply it to themselves. They are unable to apply it. They are unable to appreciate the reasonably foreseeable consequences of saying yes or no. They would say, well, I'm going to decline that proposed treatment because that sounds fine, but that's not me. That doesn't apply to me. I don't have that illness that you're talking about. So that's the legal test to keep in mind. And again, I've alluded to the fact that sometimes there are tensions between what the health practitioner hears and assesses versus your own lived experience of the caregiver and their lack of insight and the resulting behaviors. Next slide, please. Let's just pass over this one. I mentioned in passing, there's also a test for admission to long-term care if ever you need it. This is important. This is the list of substitute decision makers in Ontario under the Healthcare Consent Act, Section 20. And so everyone should, oh, actually, we'll go back to that one first. Everyone should know in the prior slide, who is your own substitute decision maker? Because in Ontario, we start at the top. Very few people have guardian of the person because that's a court order. Some will have signed a document, a power of attorney for personal care. Many haven't, especially if you're talking about kids. I think you have to be 16 to sign one. We always want to take a look. If there is one, what does it say? A representative is someone appointed by an arm's length tribunal called the Consent Capacity Board. You know, if you thought, wow, I can't believe that my person appointed someone inappropriate, for lack of a better word, you could go to the board and ask that it be you, or even if the person's incapable, they could go to the board and ask that it be someone else. And then the next ones are mainly family, spouse or partner, child or parent. I know some of you are parents in your situations, or you could be the adult child of an elderly person. Sometimes we have like the 25-year-old daughter of the person and an elderly parent of the person. Maybe that person's in their 40s or 50s. If there are two or more substitute decision makers equally ranked, they have to make the decision together. And I think I'll talk about that in a minute. There are also some nuances of access parent versus custodial parent. So number 5, custodial parent, and then access parent ranks below. But there's some things in family law that you would also need to be aware of. If, you know, is there a court order? Is there anything to level the playing field? And then all kinds of other relatives, public guardian and trustee, substitute decision maker of last resort. So we'll go to the next slide, which is what is the criteria to be a substitute decision maker? You don't have to be one if the person's found incapable. You have to be willing. So you could say no, you could say not for this decision, but some other decisions. You have to be willing, available, at least 16, not prohibited by court order or separation agreement. You have to be capable yourself. And sometimes in familial situations that, you know, we sometimes see that, okay, the person who's making the decision is also incapable, and then they may get bypassed. What guides someone making a substitute decision for someone else? best interest sounds terrible. It sounds paternalistic, but that is the language of the statute. And it really means if your person made a wish while they were capable, let's say between bouts of illness, they capably said, you know, I hated when I was on that medication and how it made me feel. And I'm telling you right now, I'm going to tell my doctor and everything else, I do not want in future to be treated with that medication. As a substitute decision maker, your job is to interpret their wish, including a capable wish they made in the past. And I've had some really hard cases and hearings at the Consent Capacity Board where, you know, the parents went and said, listen, you know, we want to make a decision for our son and or daughter. And ultimately, because there was an intervening capable wish by that person, it took a hearing to figure it out, but ultimately they were bound by the prior capable wish. And I know that sometimes that can be quite distressing for families. If, let's say I didn't make a prior capable wish ever, then it's on the substitute decision maker to just look to the person's values and beliefs and figure it out. The decision is not the doctor's. The doctor doesn't make the decision about yes or no to treatment. They can propose the treatment as well. Let's just see, and I've already said, if there's a substitute decision maker for treatment purposes, they also make the information decisions also. So I've just brought my chat back up. So one question that someone is asking, how does a substitute decision maker relate to the living will? I mean, living will is not a term that we use in Ontario. We don't use advance directive either. I guess it's whatever form your prior capable wish is in. It could be verbal. It is often written. If someone has written a power of attorney for personal care, they would set out their wishes. Sometimes a power of attorney for personal care only says one thing. It says, I don't want antipsychotics in future, or most often, it doesn't say that. It's just very general. If and when I become incapable, I appoint so-and-so, I appoint, you know, another person as backup, and that's it. Another person has said, what am I talking about when I use the word collateral information? In Ontario, on the Form 1 application for psychiatric assessment, and we're going to talk in the next session in September about these issues at length, and we'll even pull up the form. But when a doctor, any doctor who's seen the person within 7 days and, you know, comes to the conclusion the criteria are met, they pull out a Form 1, they sign it up, and on the Form 1, there's an actual box or section that says, what collateral information is the doctor relying on to sign this form? And collateral information in that case is, did they collect it from police when the person was brought in to emerge by police? Is there someone with the patient in that case who is telling us, here's what was going on? It's collateral information in that way. Someone's asking, what if the individual always refuses treatment? If they're capable, that's their right. Doctors and team know they lack the insight to be making the right decision. Well, the question is, how does a substitute decision maker resolve? The fact is, there is no substitute decision maker until you have that finding of incapacity. But let's just say, how does the caregiver, you know, what step can they take? I think you need to keep at the practitioner, the healthcare provider, and the team. I mean, if they know the person lacks the insight, that they're bound by that test. And I think what we've got to do is bridge that gap to get them the right information, so it would be almost unreasonable for them to conclude that the person is capable. This is the challenge. I quite often find that families know the person best. And so we've got to equip the team with as much good information as possible. And I realize the privacy stuff creates barriers. Okay, so let's keep moving, but I was just looking at some of the chat as well. I better move it so that I can actually see it. So we'll go to the next slide as well. Capacity. So what if the highest ranked substitute decision maker, him or herself, let's say it's you, becomes incapable? And you remember I just said, to be a substitute decision maker, you have to be capable. And so if the team starts to think, gosh, I'm not sure that this person is capable, then that is, you know, they are not going to be turning to you. And in fact, they could bypass you. But here's a very practical thing. Often when I'm looking at these situations and a team will call me, And they'll say, this substitute decision maker is making a decision that is really objectively not great. And so I say, well, let's get to the bottom of it. Are they capable and they're making a poor decision? Or are they themselves incapable? If they're incapable, then we're going to have to, let them know we're going to bypass you and move to the next group. Let's just see. So again, if substitute decision makers don't agree, remember in that ranking, let's say they're, two parents or two adult children of a senior. If they do not agree, then we have to turn it over to the public guardian and trustee, the treatment decisions unit. So we don't have that one conversation ideally. And I'm sometimes coaching the healthcare teams. Like we have to, we'll leave it on this slide just for a second. We have to just say to, let's say the two people, sometimes I've had adult children and there are 9 of them and they all agree maybe except one. So that makes it, a little more challenging. So the issue then is we would say, if we're presented with, listen, there's no consensus, we would say to them, we would really like you guys to get together and bring us a decision. Because unfortunately, if you don't agree, it leaves us, the healthcare team, with no choice. We, by law, have to go to the public guardian and trustee. And let me say, public guardian and trustee doesn't want to have to step in and make these decisions. They're not out soliciting and looking to be the decision maker. So we really do want to make sure that the substitute decision makers have all of the appropriate information, from that point of view. So I do think that there are some things to consider on that front. It is important, if you are in a situation where you become a substitute decision maker, that you work through, that you get the right information in the hands of the healthcare team. And I know many of you do that on a constant basis, of course, by any means possible. Many times, and I know that the Ontario Caregiver Association has also done some of that work, as did the Change Foundation prior to that, to make sure that we're also giving the same information to the healthcare teams as we are to the caregivers. And I know how frustrating it can be to feel as though you are having this challenge continually. I spoke some years ago now at, I think it was a Schizophrenia Society of Ontario conference. And what I was really struck by was the fact that ultimately the caregivers, the family members, were feeling so isolated in the situation. And the panel I was on, there was it sounds like a joke. There was a lawyer, doctor, etc. But there was literally a Crown attorney who was there to explain to families why there were certain limits on what they could share. There was a lawyer who acts for patients, who is being paid typically by families for legal representation. That person got up and said, here's why I can't share information. I was there giving it the perspective of a hospital as a health information custodian under PHIPAA in Ontario to say that as well. So it really, I think it was very distressing. There was also a psychiatrist from the Center for Addiction and Mental Health who got up and said, listen, this is the situation. I'm not necessarily going to be able to share all of this if the person is capable and is telling me not to share. I know that we've had some issues with the slides. I did have a couple of, commentaries about scenarios, for example. So in one case, if you have a 15-year-old, there's no magic in the age of 15 in terms of treatment, my first point, and you'll see that when you see the slides. I said, here's a young man of 15. He's starting to seek mental health services. His parents want to know more. What could a healthcare provider tell them? Well, if he's capable and he's seeking that treatment in his own right, it will be with his consent. So that was one. In terms of dueling family members who are stepping into the role of substitute decision makers and starting to make decisions, let's say for an elderly parent facing mental health or addiction issues, the scenario speaks to, you know, what if one of the substitute decision makers wants to lock down anything about the addiction and only focus on the mental health piece, or vice versa, flip it over, then, you know, what if the other sibling doesn't agree? And that can be extremely challenging as well. And we would simply say to them, listen, we need you to, you know, bring us, as a healthcare provider, you bring us the decisions. We can help you walk through. We certainly don't want to have to move any kind of decision over to the public guardian and trustee. And most often it does work out, and people sort of step away from that particular situation. So we will be back in September. We will do a little roundup on this, minus the slide trauma. We'll be looking at the Mental Health Act, community treatment orders, police scenarios, risk management type things, tools to help you navigate, both support the person, get the information you need, and get the information into the hands of the healthcare teams. We have to equip them as best we can. I know that you're trying very hard. We've got to just knock down those barrier issue as well.
So welcome, Angie. Take it away.
Thank you. What I'm really going to talk about, I have lived experience as a parent of a child who struggles with substance use disorder and other mental health conditions. And I think really the best title for this is the conversations we aren't having. I think stigma is preventing a lot of conversations, and we've got to get over that. So just try to minimize this. Okay. There's a history to the privacy and involuntary treatment issues that exist in our province. It arises from the tension between autonomy and right to self-determination, which everybody understands and everybody wants, on the one hand, and society's duty to protect vulnerable people who may be a harm to themselves and others, or may lack capacity to make treatment decisions. So in a nutshell, we have this tension between those two things. And when there's tension, there isn't consensus. And when there isn't consensus, the politicians think there's nothing in it for them, and things tend to sit. And that's what we have. So in 2009, the province of Ontario set up an all-party committee, and they traveled the province, and they wanted to report back with recommendations on how to fix the addiction and mental health treatment system. They came back with 22 recommendations, the last two of which are the most important to families. The 21st, which we'll deal with next time, is on involuntary treatment. The 22nd involves privacy laws. And it basically was a nod to the fact that privacy laws were hindering caregivers of people with mental health and addiction. So it's not like they don't know. And this report, they interviewed service providers, people with mental health and addiction issues, and family members. So it really was a consensus that something had to be done. And this recommendation, this privacy recommendation, really says, hey, to the extent possible, let's treat caregivers as part of the healthcare team, because frankly, we are the default, case managers. We're the emergency responders. We provide housing. We make sure documents are in place. We do everything, and gladly, but we would like to be supported in doing this. And some of the things that this addressed were things with respect to privacy, like in 2008, a University of Carleton 18-year-old student went to their health services there. Obviously, she was asking for help with respect to her mental health. Subsequently, she disappeared, and 6 weeks after that, she was found dead. She had jumped off a bridge. And the parents didn't know that she was having mental health issues. So obviously they were completely distraught and felt like something should have been done to make sure that they were aware that her life was at risk. Those are the type of things we were trying to address in these recommendations. So, significant issues. The good news is the province has come out with patient first, legislation, and they want family-centered care across the province. And for an idea of what family-centered care is, I also have done a webinar, which I've included in the resources on family-centered care, which I would encourage you to look at. It's kind of the same and kind of different from this. What I would say family-centered care is, it's making sure to the extent possible under our existing laws that families are included as partners in the treatment team, that they are supported as well, that we recognize this affects the whole family. It's not just about the person with the illness, it affects all family members, that kind of thing. And I would also say, I think it includes advocating for change when the needs of families aren't being met. I am on the board of directors of UVCAN, which is the Ontario Family Caregivers Advisory Network. And I recommend those of you who are caregivers look at this, and especially if you're part of a family advisory council that isn't part of UVCAN yet, you should look at that. And one of the things we're trying to do is, promote caregivers as part of the health team and partners in care. And again, we should be included and supported to the extent possible. We, as a result of our work in our strategic planning, started asking family advisory councils for their documents on what could be done or couldn't be done to support families. And a lot of these family advisory councils have documents, and it's great because you can take the best one, and by that I mean like best practices as far as families are concerned, and try to promote it to other hospitals, et cetera, and so on. What I wanted to draw to your attention is there really is a great lack of understanding on how these laws work. And so the St. Joseph's Healthcare London pamphlet has this thing about, we need consent to share information, but if you want to provide information, go ahead. And as Mary Jane mentioned, under PHIPAA laws, there are exceptions, but they're pretty narrow, like timeliness, and if you don't think you're getting accurate information. But it's not just a global, they can receive whatever they want. And I think these practices actually are different. There's a different culture in each hospital or community health center. So we need to have discussions and make sure it's not better somewhere else or worse somewhere else, and that we're following the laws. And if the laws suck, that we look at changing the laws. So I love this. This was Billy Chan and Anne-Marie O'Brien. He was at CAMH at the time. She was, and I think still is, at the Royal. They got all excited because of the all-party committee report in 2010. And in 2011, the government came out in Open Minds and Healthy Minds and said, we're going to set up that task force that we were asked to set up to look at these privacy issues. So they got excited and they did a paper and they did this chart, and I love this. I mean, and it's dead. It has gone absolutely nowhere. What I like about this is right from the very beginning, it says you got to talk to, mandatory interview with the person who is struggling and needs services, and with the family. So you can actually get both sides of the story. And as you can see, the first box, if the person is a victim of abuse by their family, then that's different. But you get both sides to start. And as a lawyer, I can tell you, you don't know anything if you don't have both sides. And I think to a large extent right now, the medical profession is hindered by the PHIPAA laws in what they know and don't know. And they don't have a lot of training in it. That makes them nervous. They're worried about their liability. So, if there's any ambiguity, it will result in them saying, we can't share information, we can't receive information. So I would like this to have new life breathed into it, if at all possible. I think a lot of family caregivers would as well. I think it's a good thing to discuss in the future. I want to move on now to capacity. Wow, we have 10 minutes left, so I'm really going to zoom. I think sometimes physicians don't know people have to have capacity when they refuse treatment. So it's not just if you're going to do a procedure or something that, people have to have capacity. If they refuse, they have to have capacity. And the type of things that we should be looking at obviously our age, and there's no limit, as Mary Jane pointed out, but the reality is prefrontal cortex, not fully developed until mid-20s. We know this. Prefrontal cortex, decision-making, risk-taking, judgment, all those things are affected if it's not fully developed, all the executive functioning. So that is something to look at. Nature of underlying conditions. So just by way of example, in Ontario, if a teenager has anorexia nervosa and they're not eating enough to survive and they don't want to die, they're going to fail the second part of the test. And the parents are usually the substitute decision makers, and an NG tube can be inserted. What about addiction? This is where I think stigma really has a huge effect. So this happened in BC. Ali Thomas, 12, dies of her 4th overdose. This is just appalling. I don't think anybody goes, oh, good, that's some good, human rights and right to self-determination and autonomy right there. The question that needs to be asked, could this happen in Ontario? I believe it absolutely could happen in Ontario. Somebody decided she had capacity to refuse treatment. Somebody decided, and maybe 3 people decided, that she was not a harm to herself. So this is how big the problem is. And we have an illegal, illicit, toxic drug market. And we know people use drugs, including people as young as 12 years old. So we're literally just letting them play Russian roulette with their lives, because right now someone who's 12 does not have access to supervised consumption sites, does not have access to medical detox in Ontario. There is no treatment on demand if she needs residential treatment. There is no safer supply of drugs for someone her age, and we don't let parents intervene if she doesn't want help. So that's the reality on the ground of that. And we can talk about that next week in a little more detail. I want to point out, to me, the double standard, hypocrisy with our health laws as they're being applied and our human rights laws. So addiction, substance use disorder, is a disability under our human rights code. So in 2019, we had a case where a nurse was stealing pain meds from her patients. She was in a long-term care facility. She got caught, she got fired, she went into rehab, she wanted her job back. They said no. The union took the employer to the labor arbitration board. And they held, looking at the evidence, that she had to be accommodated in the workplace. And what the arbitrator said is, I find that these substance use disorders, they are a mental disorder, characterized by, among other things, compulsive behavior and either a complete inability or a diminished capacity to resist the urge to engage in behavior supporting her addiction. In other words, this severely impacts your autonomy, which is presumably the reason people are saying people have, if they've got capacity, the reason they can refuse treatment. So I would say, the situation, the 12-year-old who overdosed 4 times, and Sunnyside shows us that our human rights laws is protecting the livelihoods of functional employees, because substance use disorders are a disability and they have a detrimental effect on a person's autonomy. Yet our health laws are as drafted or applied, could be both our problem, are not protecting the lives of youth or others really with substance use disorders because of, well, patient autonomy. I'm going to wrap up. Next week, a little bit about capacity in the Starson case. Starson was a situation with someone with serious mental illness. And the question is, if someone has anosognosia, and that is what is a lack of insight or general lack of understanding that you're ill, in case of substance use disorder, sometimes it's called denial. How does that affect capacity? And this is a Supreme Court of Canada case, so that's a significant case. And they held if a patient's condition results in him being unable to recognize he's affected by its manifestations, he will be unable to apply the relevant information to his circumstances and unable to appreciate the consequences of his decision. So in other words, he's going to fail the second part of the capacity test. So I'm just going to stop right there. These are resources.
Great. Thanks so much, Angie. I really appreciate that. We will share those resources and your full slide deck with folks along with the recording. I want to just thank you, Angie, and Mary Jane for joining us today. We have covered a lot of content, some really fantastic material, and I know I took a lot away from the webinar. We've had a lot of activity in the chat box. So thanks everyone for joining us, and we're looking forward to learning more in part 2.